Hello and welcome to part 2 of this webinar on how to be prepared for the year ahead. My name is Ian McRae. I am the Head of Employment here at Field Seymour Parks, and we're going to be carrying on our look at how to be prepared for employment law developments coming up. So first thing I want to talk about in this session is about right to work checks. Now, hopefully most of you are familiar that there are civil and potentially criminal sanctions if you fail to prevent illegal working in your workforce. Now, the good news is that there is a statutory defence against such liability if you can establish that you have taken certain steps to ensure that the people working for you have the right to do so. So generally speaking, at a basic level, you need to check the original of their documents. You need to keep a copy and a record of the checks that you've undertaken, including date stamping, and then you need to follow up to ensure that anything that has a time limit right to work is followed up at the appropriate time, and then that you've kept those records so you can demonstrate compliance. Now, that's the general principle as it currently stands. The one thing I need to make you aware of is there is some new online checks which have come in as of the 28th of January 2019. Now, essentially, these only apply to limited classes of workers, but ultimately non-European Economic Area nationals who hold a biometric residence permit, or EU nationals with settled status, which you'll have heard me talk about in part 1 of this session. If you have a worker that falls into one of those two categories, you can now, if you wish to do so, check their right to work online. So instead of doing the physical hard copy check of documents, which you'll be used to doing, actually you can verify it via an online process. Now, there are a few caveats and things to be cautious about here. Firstly, you need to access that portal directly yourselves as the employer. You still need to check the photo there to make sure it bears a likeness to the person you're actually employing and it is the same person. And you still need to retain a copy of that response for at least 2 years to ensure that you've got that compliance record. But in short, you now have that as an option for those two classes of workers. I would say that if you prefer to still check their hard copy documents, you're currently able to do that, although going forward that will be more difficult for the EU nationals with settled status. One final point on right to work checks to be aware of is that you can now, as of the 28th of January, rely upon short form birth or adoption certificates rather than the full long form, provided you also have sort of proof of national insurance number as well. The reason that that is quite useful for some people is you normally have to pay for a long form birth certificate. Now you can rely upon a short form one, provided you have that additional national insurance number. So that's right to work checks. Moving on to give you a little bit of an update in terms of what's happening with employment tribunals and what's potentially on the horizon ahead. So by way of a recap, in July 2017, employment tribunal fees were found to be unlawful on the basis that they prevented access to justice, they were indirectly discriminatory and contrary to EU law. Now, the reason I flag up why they were found to be unlawful is to be clear that the mere fact that we leave the European Union does not necessarily invalidate this decision. Now, that withdrawal of employment tribunal fees has led to a dramatic increase in employment tribunal litigation. So in the period between April and June 2018, as opposed to the same period in 2017, there was a 165% increase in single claim receipts. So that single claim receipts, it's not artificially inflated by those sort of multiple class action type claims. So the short story is as an employer, you need to be ever increasingly watchful of litigation and the risk of it. There are no fees as a deterrent for claimants to issue claims. Now, the government did hint in the autumn of last year that it may seek to reintroduce employment tribunal fees. And of course, it is open for them to do so. The finding of the Supreme Court was not such that all fee regimes were unlawful, merely the one that the government had introduced. However, I think it's fair to say that it is probably unlikely in the short term that we will see a re-emergence of employment tribunal fees. And I speculate on that on the basis that the government is obviously somewhat preoccupied currently with the exit from the European Union. And ultimately, it wasn't a massive money spinner for the government. It obviously did raise some money, but in comparison to the annual budget of the government, it's a mere drop in the ocean. That combined with, as we currently talk about, Theresa May's very slim majority in the House of Commons, means I think it's unlikely we will see them re-emerge anytime soon. So that's employment tribunal fees. Let's have a look at some reforms that are potentially in the pipeline as well. So a Law Commission consultation on this closed on the 11th of January 2019. What I've highlighted here for you are some of the key proposals that you need to be aware of. So the first thing is a potential increase in the extension of time to issue tribunal claims. So currently, the time limit for most claims is 3 months, subject to extension for early conciliation. And there's a proposal that actually increases that to 6 months. There's also a suggestion that it should be easier to obtain an extension of time if you issue your claim too late. An increase on the tribunal's ability to award damages for breach of contract. Currently there's a cap on their jurisdiction of £25,000, looking to potentially increase that. And then maybe even giving the employment tribunal some wider powers, the ability to grant injunctions or indeed determine self-employed contractual disputes. Now, these are still currently just proposals, but I think it's fair to say that if these reforms are introduced and employment tribunal fees are not brought back, there's a real risk that the increase in litigation we have seen over the last year, 18 months, is not going to stop. And indeed, potentially, this could generate even more litigation than we're seeing at current levels. So the tribunal risk is not going away, and as employers, you need to be aware of that and ensure that you're compliant. So that's tribunals. The second element I want to talk about in this section is about workplace reforms. So this has been getting a lot of publicity, even in the mainstream press, and a lot of the focus has been on the gig economy, so flexible ad hoc working, and ultimately whether employment rights are extended to a wide enough group of people, and indeed whether there is sufficient rights for those people who qualify for them. What we had in 2016, Matthew Taylor produced a review on the future, essentially, of the workplace and on employment law regulation. And the government, in response to that, published its Good Work Plan. And this is in December 2018. And in their words, it's the biggest package of workplace reforms for over 20 years. So let's have a look at what we are dealing with. So I've highlighted 7 of the main proposals for you. There is going to be, or it's planned to be, a right to request a more stable contract. So if, for example, you are on a 0 hours contract, but you are regularly working, say, 20 hours a week, you will have the ability to make a formal request, much like a flexible working request, for those of you who are familiar with those, in which you could possibly ask for a contract that guarantees you 20 hours of work a week. And if, as an employer, you receive one of those, you would have to go through a due formal process and give reasons for the outcome. Looking to make it easier to establish continuous employment. So currently, a break of just 1 week can break continuity of employment, which is important for certain statutory protections. Looking to possibly extend that out so that a 4-week period would be required to break continuity of employment. So a 4-week break in work, basically. A lower threshold for informing and consulting under sort of the ICE regulations, which is where employees can request a sort of consultation body. Written statement of terms for all workers, and that is due to apply to not just employees, but all workers, so your casual 0 hours workers as well. And that is also going to be a day one right. So you need to be getting those written statements out on day one of sort of employment. Reference period for holiday pay to be amended for 52 weeks, which will be relevant for those people who, for example, regularly pay overtime or commission, which is the focus of some of our previous webinars. Naming and shaming for employers who fail to pay employment tribunal awards. And again, increased penalties for employers. So currently there is a limited right to impose a financial penalty on employers when there is an aggravating factor on a tribunal claim. They're looking to increase the level of that financial award. Now, one thing I want to pick up on when we're talking about these workplace reforms is some of the court cases that have been decided in this area. So moving away from what the government is potentially looking to do and instead focusing on the court's approach to these relationships. Now, one of the most high profile cases has been that of Uber, which you may recall I've talked about in previous webinars. And there was a Court of Appeal decision in December 2018 that in short held that Uber drivers who are treated as self-employed by Uber actually should be treated as workers. And that would mean that they would have a right to national minimum wage, holiday pay, etc. Now, I'm not going to get into the detail of that case because it's very specific to its facts. But what I would flag up is it does appear that the current position is that the courts are much more willing to question and relabel relationships than they were probably in the past. And this is increasingly a risk for employers, that the people they are treating as self-employed, or indeed maybe as workers, are in fact a different class. So are they self-employed actually workers? Should they be getting holiday pay? Or indeed, are their 0 hours workers actually employees and qualifying for unfair dismissal protection? Now, what I would say for all employers is it makes sense for you to review your contractual arrangements periodically, because what may start out as a genuine self-employed relationship may not be one 3 months, 6 months, 9 months down the line. And having those regular review periods means that you can assess your risk and ensure that your contractual relationships are still appropriate and avoid the risk of these types of claims. I should flag there is possibility of appeal. Uber want to take this to the Supreme Court and we await further information on that. If you want to be kept abreast of details on that case, then it will be something that will be the subject of our 3 employment law updates, which I'll talk about at the end. Now, how does this Uber decision fit in with the Good Work Plan? Well, the government, in terms of this idea of who is an employee, who is a worker, who is self-employed, they have, for current purposes, somewhat kicked this into the long grass. This is probably the key distinction as far as employment law is concerned. What the government has chosen to do is to commission some further independent research on this area to try and establish a way forward on this. It is unlikely, in short, that we're going to see material government legislation on the distinctions between these different types of people anytime soon. And instead, you need to focus and keep an eye on those decided court decisions. Look out for that Uber appeal, and there will no doubt be others over the course of the next year. So a few final points on this section. Usual caveat applies. This is only a very brief introductory summary. You should always take legal advice on your own specific circumstances. As I mentioned, if you want to keep abreast of things as they develop throughout the year, please just email me. We'll be very happy to sign you up for our 3 employment law updates. And again, please do get in touch with any questions or feedback you have on these sessions. And as I've said earlier, this is part 2 of a 3-part series. You can check our website or our YouTube channel for the other 2 elements.